Hello and good morning or good afternoon. My name is Ariane Hegewisch. I'm a senior research fellow at the Institute for Women's Policy Research and very happy to moderate this panel on pay equity laws. We put this panel together, most of us, as part of an organization called Equal Pay Today, which was formed on the 50th anniversary of the US Equal Pay Act, noting that equal pay or the wage gap was not really narrowing or had stagnated, and also noting that at the national level, there had been no substantive reforms to the 1963 law, but lots of innovation is and has been happening at the state level. And so what we are hoping to do with this panel is to start with a presentation reviewing what is happening in state level innovations on equal pay laws, and then two papers doing empirical investigations of the impact of two key components of these equal pay laws, one on pay transparency and the other one on salary history. The last paper, stepping out of the United States to really review two innovations, that one which is also being pursued in the US, getting organizations, large companies to report their pay gaps, and the other one which was on the books in the US but has come off, comparable worth or equal value, and particularly how far this can be introduced to or can be used to tackle low wage care work. So we have I'm really privileged to introduce the panel. First will be Trilby Robinson-Dawn, who is a professor at UC Irvine School of Law, where she runs the Pay Equity Project, and she's a litigator. Before that, she joined university. Shengwei Sun is a senior researcher at the National Women's Law Center, an ex-colleague at IWPR. Laura Adler has just graduated with a PhD from Harvard and is moving to Yale to teach there. And Heather Wakefield used to be the head of local government of Unison, the largest public sector and one of the largest unions in the United Kingdom, and now is associated with the University of Greenwich in the UK. And also want to introduce my colleague Eve Mefford, who also is a member of Equal Pay Today and will also help us move the slides, but kind of full colleague. So maybe if everybody could put brief information about them in the chats, it always helps to know who's on. And also what we're hoping to do is to, I forgot Pamela Handon, who is actually, she's also in the steering group of Equal Pay Today and the co-chair of their communication committee, as well as the CEO of the KWH Law Center for Social Justice and Change in New Mexico, and she will lead the discussion after the others have presented. But if you have questions, please put those questions in the chat and we will read them out or call them out at the end. And the goal is not to take questions between sessions because it's such a packed session. So with no further ado, Eve, can you do next slide and starting Trilby's presentation.
Great. Thanks you so much, Ariane, for that nice introduction, and welcome everyone. Good morning from California. I know we're all in different time zones. I wanted to quickly cover three topics on related to state equal pay law developments before handing it over to my co-panelists. The first is a brief summary of why state statutes are increasingly important in working to close the pay gap. The second is a few of the important recent state equal pay statutory developments by category, since in the time we have, I can't possibly cover all of the states. And the third thing I'd like to cover is a few recent cases that address new state pay law, pay equity law provisions, although a bit of a spoiler alert that these laws are so new that there really isn't a lot of case law out there yet. So next slide, please. Thank you. So why is state law increasingly important in working to close the gender and race pay gap? As many of you probably already know, the Equal Pay Act, which is our primary federal pay equity law, together with Title VII, has proven to be of much more limited utility to plaintiffs than initially anticipated. And why is that? So briefly, in addition to challenges workers have just in general bringing litigation in the first place, such as access to lawyers, cost, fear of repercussions at work, the limitations in the language of the EPA itself and judicial interpretations of the EPA have essentially almost closed the courthouse doors to many plaintiffs. For example, and I've noted a couple of these things on the slide. First, the EPA contains a narrow mandate of equal pay for equal work. So in other words, the jobs being compared must be substantially equal in order to give rise to a claim, which has meant that plaintiffs have had to demonstrate that they perform virtually the same work as a male comparator, yet receive lower pay, which can be a very difficult hurdle. Second, under the EPA, the jobs being compared must be at the same establishment. That's meant, for example, that male employees who perform similar work at another office of the same employer in the same county may not count as the necessary comparator needed to bring the EPA lawsuit. Third, the EPA contains 4 affirmative defenses that employers can use. Most significantly, a broad catch-all that's known as the factor other than sex defense, which is also incorporated into Title VII. The broad interpretation of this defense by some courts has allowed employers to use factors that are unrelated to the job at issue to justify pay disparities, such as prior higher salary of a man in a job at a different company, or better alleged salary negotiation skills, even if those factors themselves are actually based on sex or partially based on sex. And finally, the EPA does not contain salary reporting or other pay transparency requirements. So that means that many women do not have the critical information about their coworkers' salaries needed to bring an EPA claim for unequal pay in the first place. So like Lily Ledbetter, many of you probably know about that case, many women either never know or don't know for decades that their male coworkers are earning more of them due to a lack of transparency. So advocates have tried to amend and improve the federal EPA for closing on 25 years now without success, most recently in 2021. So as Ariane noted at the beginning, legislative reform efforts on the federal level have not been successful, to say the least. Since that's been the case, advocates in numerous states have stepped up to try to fill the gaps and deficiencies in the Equal Pay Act by drafting and proposing more protective state statutes and amendments, increasingly so since 2016. So basically state law is where the action is right now in terms of enacting more progressive pay equity laws. Next slide, please. The next thing I'd like to discuss are just to quickly highlight some of the important recent developments in the state statutes. First, several state statutes now mandate equal pay for substantially similar or comparable work rather than the EPA's narrower equal work that I talked about a second ago. So for example, without trying to list every single one, but for example, California, Colorado, Washington State, Illinois, and New Jersey prohibit disparities among employees performing substantially similar work, or those who are similarly employed, which again is broader than the EPA's language. As another example, Massachusetts, Oregon, and Maryland arguably go even farther and prohibit disparities among employees performing comparable work. Second bullet on the slide, several states have enacted laws that narrow the defenses employers can use to justify pay differentials. At least one state, Massachusetts, has entirely done away with the factor other than sex catch-all defense. And then a number of other states, including some of the ones I listed a second ago, but New Jersey, California, Oregon, Washington, New York, Maryland, Connecticut, Illinois, have narrowed their defenses significantly so that a factor other than sex in those states has to be bona fide or consistent with business necessity or job related. Interestingly, the New Jersey statute provides further that there has to be no alternative that would serve the same business purpose. So these are all pushing the envelope on the breadth of the defenses employers can use. Third, there are a few jurisdictions that have enacted pay range disclosure laws. As of January 2023, Washington State will join Colorado and New York City in requiring salary range disclosures in every job posting. So the Washington Equal Pay and Opportunity Act was recently amended. Colorado's law already did that, and even went a step further in also requiring employers to notify current Colorado-based employees of promotional opportunities at the company. Fourth, a few states have enacted pay data reporting requirements. Illinois is the latest state to do that, to pass a pay data collection law, joining California as in doing so. As of 2023, employers in Illinois that have more than 100 employees are going to have to report pay data and obtain an equal pay registration certificate. That's also the case in California, where that's been the case since 2020, in order to help the state identify wage patterns and assist with enforcement of equal pay laws. Fifth, a number of states have added protected classes like race to their equal pay statutes, basically prohibiting pay discrimination, not just based on sex, but also based on race, sometimes sexual orientation, et cetera. More than 20 states have done that. And sixth, more than 20 states have enacted salary history bans. This is a really important one, and one that'll be discussed later in this panel. These bans prohibit employers from seeking or relying on information about the applicant's prior salary or compensation history, since that can bake sex and race discrimination from prior jobs into the new salary. And I know Laura Adler is going to talk more with you about that. This has been a very active area of state legislative change in the past few years. Next slide. So given the recency of many of these state statutory enactments, you probably won't be shocked to know that there's not a lot of case law on a lot of these things yet. There's simply not, the cases simply haven't worked their way through the judicial system to the point where there are, have been trials or a lot of summary judgment or other orders issued. And as I mentioned earlier, it's also difficult to bring these cases. So there's not a rich body of case law to draw from yet. Ideally, I'd love to be able to tell you, this X state has interpreted Y provision that I've already mentioned to you in a way that really opens the door to a lot more actionable claims, but we're not really there yet. But I do want to highlight two categories of cases involving state equal pay law to highlight and kind of to watch. The first is legal challenges by industry to more far-reaching state law statutes. So in Colorado, which I've mentioned has one of the more far-reaching statutes, the Rocky Mountain Association of Recruiters, which is a trade organization of recruiters and search firms, actually sued to try to enjoin the state's new pay equity law, or to get an injunction to prohibit it from going into effect. The recruiters challenged the portions of the law that required the salary range to be disclosed, and they challenged the portion of the law that required promotional opportunities to be posted to all current employees in Colorado. They lost. Again, they tried to argue that the Dormant Commerce Clause of the Constitution was improperly burdened by these provisions, and the court found no evidence to support that argument, denied their request for injunctive relief, and then later the case was dismissed. So I think that's notable that industry tried to strike that one down and failed in doing so. The other category that I want to quickly mention are cases out here in California where I am that are working their way through the system with state equal pay law claims challenging the use of prior salary to set pay, and also using the broader substantially similar standard that the California statute uses. So the use of prior salary is kind of a complicated legal area, but I'll just say a few quick things about it. Federal and state courts right now are mixed on whether setting salary based on prior salary can be a defense to a claim of equal pay. And the US Supreme Court hasn't taken up this issue yet. But basically in the Ninth Circuit, after the Rizzo case, which was a 2020 case, you're not able to rely on prior pay to meet the burden of showing that the factor other than sex defense in the Ninth Circuit. And then states within the Ninth Circuit, some of them like California, Washington, and others have a state ban on salary history and some don't. But there are two pending class actions in state courts in California that involve the use of prior pay to set compensation that I think those of us who are interested in these issues would want to track. One is the case against Google, LSV Google, and the other is case against Oracle, Jewett v. Oracle. Both were certified as class actions, which is huge, meaning that the whole group of similarly situated women were allowed to proceed as a collective action with these claims. But they haven't been resolved yet. They're still working their way through the courts. Two things to note there. What is the court going to do about the use of prior salary in these cases? That'll be really interesting to see. And also the use of the broader substantially similar language. What will the courts rule there? And will that potentially open the courthouse doors more, I guess, at least to women in California, where this is the standard? And hundreds of millions of dollars are at stake in both of these cases. So I believe that's all the time I have. Thank you so much for listening. I'm happy to take your questions later, and I will hand this over to my colleague Sheng Wei now. Thank you.
Thank you so much. And Sheng Wei, over to you.
Hi, everyone. Today, I'm going to present some very preliminary findings on racial ethnic disparities in being subject to workplace pay secrecy policies among women. And next slide, please. And starting with some context, pay secrecy policies refer to formal or informal policies that ban or discourage workers from discussing wages and salaries. Next slide, please. And we knew very little about the extent of workplace pay secrecy until fairly recently. In 2010, the Institute of Women's Policy Research partnered with the Rockefeller Foundation and conducted the first national survey that asked about pay transparency at the workplace. The survey found that nearly 1 in 5 workers said their employer formally banned discussion about pay, and that half of all workers in the US said they were subject to a pay secrecy policy of some kind. These results were surprising given that the National Labor Relations Act in principle protects workers' right to discuss their pay. But in practice, the NLRA has many loopholes limiting their effectiveness. At the time of the IWPR survey, there were only 6 states with state-level legislation banning pay secrecy rules in the workplace. Next slide, please. And as Tropy highlighted, since then, more than a dozen states, including District of Columbia, adopted laws that explicitly ban retaliation against workers who discuss pay and prohibit employers from requiring workers to waive their right to discuss pay. Next slide, please. To evaluate the impact of these recent laws, state-level laws on pay secrecy policies in the workplace, in 2017 and 2018, I was part of a research team that partnered with a survey research firm, GfK, to field a nationally representative survey of US full-time workers. We found that the pay secrecy policies remain prevalent despite tightened legal restrictions. We also found that public sector workers and unionized workers are much less likely to be subject to pay secrecy policies, and that women are more likely to work under pay secrecy than men, but women are also more likely to discuss pay despite being prohibited from doing so. Next slide, please. The survey question on workplace pay secrecy policy in our survey replicates the same item from the IWPR Rockefeller survey. Very quickly, respondents were asked to indicate whether which of the following statements best characterize their workplace, whether wage and salary information is public, or the information is not public, but such information can be discussed in the workplace. And in comparison, in a more secretive context, the discussion of wage and salaries is either discouraged by the managers or is formally prohibited. Next slide, please. So no research has looked at racial ethnic disparities in being subject to pay secrecy policies at the workplace. So the following analyses draw on the same survey data that we collected before in 2017 and 2018 to examine racial ethnic differences among women in the likelihood of being subject to workplace pay secrecy rules. And because of sample size restrictions, we combined the 4 category pay secrecy policies into 2 categories. One indicates more public or transparent context, and the other more secretive context. And also due to sample size issues, we focus on comparisons between white, Black women, and Latinas. Next slide, please. Our analytic sample is restricted to full-time employees aged 18 and over who are not self-employed. Next slide, please. To dive into the findings, among full-time workers, surprisingly, a lower share of Latinas than white women and Black women were subject to pay secrecy policies at work. And so why is this? The following analyses test a few hypotheses. Next slide, please. First, the key finding is that Latinas are most likely and Black women are least likely to live in a state with pay secrecy laws. This pattern potentially reflects the efficacy of state-level anti-secrecy laws, or the fact that states that have banned pay secrecy may also have passed other laws that protect workers' rights.
You need to control, Deb.
Ellen, you're on. Oh, sorry. Is that a question or? Okay, I'm gonna move forward. Second, prior study indicates that workers covered by union and public sector workers are less likely to be subject to pay secrecy at work. However, we find a lower share of full-time Latino workers than white women and Black women were covered by union and work in the public sector. So this is less unlikely to contribute to the higher likelihood that Latinas are, working under a more transparent context. Next. I also hypothesized that working in professional and managerial occupations elevates the risk of being subject to workplace pay secrecy, as wage variation in these policies tend to be wide with large room for negotiation. And these occupations are also most often highlighted in lawsuits about equal pay and where non-disclosure agreements are more common. But less expectedly, we actually found that women in administrative, support, and retail occupations are more likely to face pay discussion restrictions than women working in management and professional services and women working in service occupations. In results not shown, a much lower share of full-time Latina workers, about 1/3 of them, than white women and Black women work in professional and managerial occupations where pay secrecy policies are less common. Next slide. To formally test these hypotheses, results from logistic regression models suggest substantial differences in the likelihood of being subject to pay secrecy in the workplace between Latinas and white and Black women. And these differences remain after controlling for whether living in states with anti-secrecy laws, sectors, union coverage, education, and major occupational groups. And more specifically, in Model 1, controlling for whether living states with anti-secrecy laws slightly reduce the differences between Latinas and other groups of women, meaning the differences can be partly contributed to this factor. And in comparison, when controlling for sector and union coverage in Model 2, major occupation groups in Model 3 and level of education in Model 4 actually increase the racial ethnic difference, reflecting the fact that a lower share of Latinas than white or Black women worked in the public sector, were covered by union, and worked in occupations where workplace secrecy policies were less common. Less prevalent. So in other words, had Latina women had the same level of education or working in the public sector, union coverage, or certain occupations, the differences might be lower. So next slide, please. In conclusion, among women in the sample, and again, the sample focuses on full-time workers, Black and white women are more likely than Latinas to work in workplaces which restricts their rights to freely discuss their pay. And the sample size is small, so which is a caveat, although, it might be too small to do a full analysis of racial ethnic differences by gender. The fact that Latinas are less likely to say that they are discouraged or prohibited from discussing pay, and that fact that they're more likely to live in the states with anti-secrecy laws suggests that labor laws at the state level do matter. And similarly, the fact that many Black women living states, about 70% of them living states with particularly weak labor rights laws, may impact their rights to freely discuss and negotiate their pay. And finally, another caveat is focusing on full-time workers excludes a substantial share of the workforce, particularly among Latinas. So there are many further inquiries that could be pursued, but I conclude my presentation with these preliminary findings.
Thank you so much, Shengwei. And now I'm going to hand over straight to Laura, who's going to share the screen. Yeah. Okay, Laura.
Hi, thank you. Can you all see my slides? Yeah, it's okay. Great. Hi, and thank you so much for including me in this fantastic panel. My name is Laura Adler, and I am a PhD. I just finished my PhD at Harvard, and today I will be presenting a paper called The Expectations Penalty, which explores dynamics of information and discrimination in employer responses to the salary history ban. So a little bit about the salary history ban. Lots of research demonstrates that employers rely pretty heavily on candidates' own salary history in setting pay. So if you want to set pay for a couple of new hires, the first thing you'll typically do if you're an employer is ask what they were making before. This is interpreted as their sort of personal market price, and you'll then offer them slightly above whatever it was they made in the past in order to induce them to come to your company. Of course, this reproduces existing gender pay inequality insofar as women were paid less than men on average. Basing pay on past pay reproduces that inequality into the future. As a result, as my fellow panelists have already discussed, a spate of recent laws have prohibited employers from asking about candidate salary history. And in this talk, I'm concerned with what happens when that salary information is prohibited. Now, I think this is interesting because it sheds light on some dynamics of information and discrimination in the hiring process. So suppressing information, particularly information that bears the mark of past discrimination, can lead to an increase in the meritocratic nature of decision-making. So if employers don't have access to data points that are subject to bias, in theory, they're going to be forced to set pay based on more meritocratic job-relevant factors. But some research also suggests that suppressing information can reproduce inequality in unexpected ways. To illustrate this, I'll use the example of Ban the Box. So Ban the Box was a movement to prevent employers from asking job candidates whether they'd ever been convicted of a criminal offense. This was a great idea. Employers, many people thought, were discriminating against people with criminal records who were disproportionately men of color. But what researchers have found since then, and this is a figure from Egan and Starr, is that this had some unanticipated effects for racial inequality. Basically, prior to Ban the Box, when employers could still ask the question, Black and white men were treated similarly. They received similar rates of callbacks. Less so if they had a criminal record, more so if they didn't, but it was similar across racial groups. Subsequent to the passage of the law, though, what you find is that employers basically treat Black men as if they all had criminal records and white men as if they didn't. So Black men receive callbacks at the rate at which people with criminal records had received callbacks prior to the law. And so in this paper, I'm interested in how employers respond to prohibitions on access to information. How do they change their decision-making processes? And how do those responses intersect with demographic inequalities? I use something called a full cycle method in which you leverage the different strengths of various data and methodologies in order to gain multiple viewpoints into a phenomenon. So I'm going to very quickly run us through the findings from 3 studies that are part of this paper. So the first study tries to understand whether salary history disclosure in fact disadvantages women. So for this study, I use survey data from PayScale on 367,000 respondents, a quarter of whom answered the survey after a salary history ban went into effect in their area. This survey included a question which asked whether they had disclosed their salary history at any point prior to receiving an offer. And what you can see here is consistent with prior research. Between half and 2/3 of respondents never ask and are never disclosed, but a substantial minority end up disclosing their salary history during this process. I use OLS regression, predicting logged hourly wages, in order to understand what the effect of this disclosure is on the pay offer they ultimately receive. I find that disclosure is associated with a 3.1% increase in pay, but women see only half the benefit that men see. So here you can see the interaction between gender and disclosure wipes out about half that benefit of disclosure. And so a big caveat here, I don't have information on the candidate's actual past pay. So this is the cumulative effect of both disclosing and whatever salary history you're bringing into that conversation. So the cumulative effect of having a lower salary and disclosing the lower salary for women. I see similar size of effects before and after the salary history ban. So what's the takeaway here? It's that the salary history ban is a pretty good idea, right? using salary history is delivering more benefit to men than women. In study 2, I then start to explore how employers respond when they can no longer ask about salary history. In this study, I draw on 83 interviews that I conducted. 67 of these are with organizational representatives who describe the process of setting pay at their company. An additional 16 interviews were conducted with experts who talked about the pay setting process more broadly. I collected these interviews in the immediate run-up to and aftermath the implementation of salary history bans in California, Massachusetts, and Los Angeles. And here again, I'm interested in how employers change their pay practices when they can no longer ask about past pay. So the first thing I find is that employers were in fact relying quite heavily on salary history prior to the law. So I saw this again and again and again. People said things like, it's been the standard my whole career for making an offer. It's based on what are you making now? As a result, there was a lot of frustration about the salary history ban. This person was exasperated when he said, if they can't tell a recruiter what they're paid, how do I know what to offer? He went on to say that the salary history ban was a totally misguided law because it didn't really understand what recruiters and compensation specialists were trying to do. So in the face of this frustration, what I found was very quickly a new consensus emerged. Instead of asking about salary history, employers would ask about salary expectations. Here are 2 quotes, but I heard this in essentially every interview I conducted. People say, the law prohibits us from asking about salary history, but it doesn't prevent us from asking about candidates' expectations. And the second respondent summed it up quite nicely, saying, people now say, what are your expectations? He said, I don't think it's wise, but it's clever. It doesn't violate the law. So I've heard that's the way people are getting the information that they think they need. Study 3 takes up the question of how this response, how the use of expectations then intersects with gender. So I have 2 hypotheses. The first question is, how does using expectations instead of history affect pay offers? Well, employers frequently talk about how candidates are likely to inflate their expectations artificially. This respondent was representative of this way of thinking when he said, some people are going to shoot for the moon because they think, wow, I can ask for anything and see what they pay me. And so my first hypothesis, very intuitive, disclosure of salary expectations results in a lower increase above what you've asked for than conveying your salary history, which is this more concrete information. The second question is then, how do expectations intersect with gender? Here, there are 2 sort of countervailing factors. On the one hand, employers know that men tend to overstate their expectations. So employers talk about how women don't negotiate as much as men do. Men are more likely to exaggerate or negotiate more aggressively by staking out high expectations. But on the other hand, of course, women have lower average past pay. So if you're trying to ascertain the underlying salary history below the expectations, you might be bringing in those assumptions about women's lower pay. So for a variety of reasons that I won't get into today, I believe that employers are going to be more guided by the latter, and women will experience a larger penalty for conveying their expectations. So employers will discount women's expectations more so than men's. I test this using an experimental method called conjoint analysis, in which you present respondents with a pair of profiles with a bunch of attributes that are random, where all the factors are randomly varied simultaneously. And the key attribute here is the salary information, which is displayed either as current salary or expected salary. The outcome is that I ask each respondent to set pay for the candidates. I conducted this experiment with 928 HR professionals, and the outcome, the dependent variable that I'll be showing you momentarily, tries to standardize for the fact that these amounts were randomized by using what I call the increase. So that's the offer minus the salary information that was conveyed in the profile. So this is how conjoint results are presented. This is called the average marginal component effect. It's the average effect of that value on that variable over all the other values of all the other variables. All you really need to understand is that the effect of conveying your expectations is large and significantly negative. So you're going to be paid much less over your expectations than over your salary history. That's to be expected, right? Like, we expect people to get a pay increase when they move from one job to another, and we expect that expectations sort of fold in that increase. And so this is all to be expected. What's maybe more surprising is that this expectations factor outweighs all the other factors, including having an additional 8 years of experience, an additional MBA, or being in the top 1% of performers at your prior job compared to the top 50% of performers. The second hypothesis is that women would experience a larger penalty, and I find support for that as well. Women are experiencing a penalty roughly 50% larger than men. So the conclusion is that employers know that men are inflating their pay more on average, but employers' pay decisions discount women's expectations more than men. So what does this all mean? Well, we've seen a proliferation of policies that aim to reduce employment inequality by prohibiting access to information. You can think of ban the box or salary history ban. You can also think of blinding resumes, right? Trying to reduce information about the candidates on the resume to reduce bias, or you can even think about prohibiting or colleges moving away from the use of SAT scores in their admissions decisions. My interest here is what happens when information is suppressed. I find that employers are seeking out alternative sources of information and that those alternatives are more uncertain, and being more uncertain, they tend to disadvantage the disadvantaged. Specifically, and I'm almost done, I realize I'm over time now, prohibiting information, I argue, leads to these double binds for disadvantaged groups. The suppressed information, salary history, was in fact disadvantageous to women, but removing that information increases uncertainty, and employers fill in the gaps created by that uncertainty with assumptions that also disadvantage women. That's it for me. Thank you guys so much. I look forward to your questions.
Thank you very much. Eve, can you share again? And would like to introduce Heather Wakefield now from University of Greenwich. Heather? Are you on mute?
I'm now unmuted, sorry.
Okay.
Yes, thanks very much, Ariane, and hello, everyone. I'm going to talk about two bits of research I've been involved in at Greenwich University, which of course have occurred in a very different context from the one you're talking about. The first one, the research for the Scottish Government, we were asked to look at international mechanisms to revalue low-paid women's work, care, cleaning, catering, retail, early learning work. And the second, we looked at the impact of austerity on the gender pay gap across Europe and trade union actions to mitigate the impact of austerity on the gender pay gap. And of course, we're talking here about a context in which European law has embedded the principle of equal pay for work of equal value since 1958. And that principle has in some ways had to be incorporated into national laws, and it has been incorporated in very different ways. But both pieces of research highlighted for us, and there are overlaps in the teams, the limitation of gender pay gap reporting and the concept of the gender pay gap, we felt very significantly. In the case of, could you move the slide on actually? Sorry, thanks. That just tells you about the research. In the case of the European study, few trade unions had awareness even of the equal pay legislation and equal pay case law, which is significant in the European Court of Justice. We found it very difficult to find examples of use of equal pay law either in litigation, in negotiation, or importantly, from our point of view, in terms of developing job evaluation schemes that provide equal pay for work of equal value in pay systems. And although most countries have gender pay gap reporting mechanisms, in the main, we found them to be ineffectual, which is partly to do with the schemes themselves, but we also came to the conclusion that focusing too much on pay transparency meant that people were taking their eyes off the ball in terms of using the legislation that existed and developing mechanisms, particularly job evaluation, to deliver equal pay for work of equal value. And I am very aware that we're talking about very different contexts in terms of the law. Could I have the next slide, please? Okay, so in terms of the limitations, there's generally no requirement for action, for follow-up action plans in the European gender pay gap transparency requirements. There is no race equality dimension in, I say here most, but I think almost all. There are very weak sanctions for non-compliance with gender pay gap reporting, and the gender pay gap measure itself hides, as you will realise, a multitude of sins that are difficult to disaggregate and sometimes measure. Doesn't tackle the failure to provide equal pay for work of equal value, excuse me, where there is legislation. And a very strong feeling that wage history, a focus on wage history, individualizes the problem and undermines potential for collective bargaining. And an important point in the gender pay gap we feel is the privatization, particularly of public services, and outsourced workforces are generally excluded from public sector gender pay gap reporting. Can I have the next slide, please? Right, as I've said, there was a lack of awareness about equal pay legislation, and we felt very strongly that the European Union and nation states have failed to promote the law, the case law, or require any compliance whatsoever. And this is an important lesson for people to learn. The law itself is weak in many nation states within Europe. No provision for class actions. There is a failure to level up, meaning that equal pay is delivered through leveling down, and men's pay is cut rather than women's pay raise. It's impossible to compare across sectors, and comparisons between public and privatized workers are not permitted. And lastly, job evaluation is generally not used to create equal value-based pay systems which are sustainable. And that's a very important point, the sustainability of pay systems into the future. Next slide, please. Okay, some positive developments. I'm not wishing to sing the praises of the UK in particular, but it is unfortunately or fortunately the case that it's really only in the UK that public sector job evaluation schemes have been designed and applied to achieve equal pay proof pay and grading systems. And that's true within the National Health Service, within local government, within higher education, within police forces and the civil service. They're different schemes, but largely they deliver equal pay proof pay and grading systems. Belgium has strong legislation which requires the development of JE schemes at company level with technical support, not in the public sector, but actually there's been very little progress. This work, the Australian Fair Work Act, comes from obviously the work we did for the Scottish government, and that's a very important case in the sense that the Fair Work Act provides for trade unions to take cases to the Fair Wage Australia, which is the tribunal. And there was a very important case for social and community sector workers, which was won through the Australian Fair Work Act. In New Zealand, which incidentally, along with Norway and Jersey and Guernsey, that are sort of part of the UK, use the local government job evaluation scheme from the UK as the basis for much of their job evaluation work. It is possible to have sectoral fair pay agreements, again, without individual litigation. So, you know, class actions and without the necessity for individual women to take cases. And in Switzerland, I mention this particularly because there's a Charter for Equal Pay in the public sector, particularly, which limits awards of contracts to employers who don't have strong equal pay provisions within their procurement legislation. That's a very quick gander through. I mean, my conclusions for all of this is that, first of all, a lot of this, the positive developments wouldn't have happened without equal pay coalitions of women's organisations, community organisations, trade unions, lawyers, and so on, that they've been really important, but that actually we're not learning international lessons. Certainly, I think we're not learning the lessons around race that have been developed within the US, and that we need to do an awful lot more of it. Thanks.
Thank you very much. So I now hand over to Pamela to start our questions as discussion.
So thank you, Ariane. You know, this has been a very insightful presentation of a vast area affecting women and their pay. And I just want to share some of what I think I heard before we go into that discussion. You know, primarily, it sounded like if women were to receive higher starting salaries when they go into their employer, that then they received lower pay increases during the tenure of their employment. So that's an interesting concept of how things go. And if there is a way to negotiate I'm wondering if there's a way to negotiate when salary increases would occur if someone were to negotiate a higher salary. So that's something to think about based upon the evidence that was presented to us. And it also sounded like when we look at this pay history in the background, that employers, if they can find a way to secure the services of an outstanding employee, that they will pay them less. And it was happening more often to women than it was ever happening to men. But what I also heard was something really exciting. So to advocates who are out there fighting for equal pay laws, that there were two things that I heard this panel tell us that we must absolutely pay attention to. That one, when we engage in a campaign to get higher pay and equal pay for women, that what we must do if the law is passed is we have to engage in aggressive campaign to let them know that this law has been passed. But then after the law is passed and you engage in that campaign, you must test the law. And I just want to bring to you a story about what happened in New Mexico. So we engaged in getting the Fair Pay for Women Act passed here. And it was signed into law and we were so excited. And then women actually started applying to see how that law was going to affect them and to change them because we encouraged them to do so. And the majority of the people who were applying to say we are not being paid fairly were women who worked for state government or in governmental entities. Well, what happened next? None other than the governor said, well, hey, this Equal Pay Act was never intended to apply to governmental employees. And so she took us to court, or rather we took her to court, and we said, oh, yes, it was. And so we went to the Court of Appeals, and then we went to the Supreme Court, and the Supreme Court said, yes, I agree with you, advocates. That law applies to everybody across the board. And these women were primarily working in positions that had been dominated by men. For example, a lot of them worked for the Department of Corrections, and they were not getting paid the same salary. But after this law and after the challenge in the Supreme Court, we saw a different direction going. As a matter of fact, one of the lead women who brought the case is now sitting as the secretary of the Department of Corrections. So we're expecting her to make sure that women are paid fairly. And I also just want to bring up the last point before we go to questions, is looking at this concept of pay data collection. So even if you have it in your law or you're able to get it, how is it used? And one of the things that was brought up by our last speaker is that these contracts are incredibly lucrative and that businesses enjoy engaging in them with respect to governmental entities. But if you require if you require these private entities to show that they're paying women fairly, that they're not segregating women into jobs where women are nearly always a place, maybe in a secretarial position, and not promoting them or showing that they are being advanced in any way into higher managerial positions, then they don't get to participate in these governmental contracts, which are incredibly lucrative to the success of their business. So we encourage people to do that. In the city of Albuquerque, New Mexico, I'm sorry, in the city of Albuquerque, that's right, in the state of New Mexico, that was something that we encouraged the mayor to do and that he has implemented. So if you want to do business with the city, participate in these lucrative contracts, you must first present an evidence that you are paying women fairly. So all of these are really great ideas that are coming up, that are stepping up, and that we need to make sure are happening. So I do want to ask the question regarding our speaker who spoke about salary bands and whether or not those salary bands, what happens with respect to them. But the big question is, do employers actually go back and check to see if you're telling the truth? I mean, were men actually telling the truth when they said, oh, I was making $100,000? Do you have any evidence to show that? Can you share some information?
Yeah, so a couple of the respondents I spoke to described working for companies that would actually fall. So when they were allowed to ask about salary history, there were some employers who would go and check and make sure that the salary history reported was in fact the salary history that you had. They would ask for a W-2, or they would, I think it's sometimes even reported through background checks. And if they found out that you had lied about your prior salary, you could be terminated immediately. And there are sort of like famous stories of this happening that probably are more larger in people's minds than as a phenomenon in the population. But salary history was widely seen as a verifiable piece of information, whereas salary expectations are by definition unverifiable, right? Your expectations are whatever they are. And employers under a salary history ban can't actually go back and check your salary history because they're not supposed to have access to that information.
Oh, well, now that's very interesting. So thank you for sharing that. Trilby, let me just ask you this question. You talked a lot about the states that are creating these pay equity laws, because we saw what was happening on the federal government level was not very effective. That 1963 Act has been largely ineffective. But are there any further developments in state pay equity law that may be helpful that you can share with us?
That's a great question, Pamela. I would say, I mean, this is maybe a little bit tangential to what you asked, but to me, the biggest development that would be helpful is something you alluded to a few minutes ago, which is the testing of some of the laws, right? I mean, we do have a few cases working their way through the system, but in other states like Massachusetts, for example, which has a very progressive law, there was a big case initially that settled. I mean, there are a few examples of this where obviously cases settle, so we don't really have the testing of some of the laws that are out there. I think when the laws are tested and develop more, that could lead to other states that don't have the progressive laws potentially adopting them. I mean, obviously it's very political too. There are some states that I'm not optimistic will ever adopt the progressive laws. In fact, Mississippi was the last state to enact a pay equity law just recently, and it's a very non-progressive pay equity law. So there is such a thing as having a bad, obviously, state pay equity law too. The other point to make, I guess, is that there were a couple of years where we had, as I know Laura knows, a big explosion of salary history ban laws. I mean, all within like a year or two, just tons of states passed those. Where we are, this sort of cutting edge right now, I feel like, are the mandatory pay range disclosure laws, like the one that I mentioned in Colorado that got challenged by the industry group, and now Washington State too. So that to me will be interesting to see whether other states follow suit with the pay range disclosure laws in the same way that states did with the salary history bans, because obviously that was immediately challenged in Colorado by industry as, whoa, what do you mean? We have to put pay range in every job posting. That's unconstitutional, and they lost. So I mean, that, I guess personally, I'm hoping that means other states will try to enact those provisions, but it's hard to know.
Well, thank you for that information. But let me just throw something out now, as we talked a little bit about talking about your pay. within your own employment, and within your employer's area and your work area. But as I think about this more and more, I keep wondering, why wouldn't you want me to discuss my pay with others? It shows two things. Number one, that you're treating every single person in the workspace equally and fairly. But not only that, once you show that you're treating your employees equally and fairly, then you're looking at loyalty. People are going to want to stay with you longer. And then that's good for your business, because it will continue to grow because of the stability within the workplace. So what did you find out about why were employers so adamant about not wanting employees to talk about their salary? Help me with that one. Xinwei, what are you thinking?
Yeah, in my thinking, it's about information is power. And when workers have power to, especially for those disadvantaged group like women and workers of color, finding out being underpaid, then workers would have the tools and information to advocate for higher pay, and the employers don't like that. I think that's one of the key dynamics of why withholding information is keeping a more leverage over the workers.
Well, thank you for that. Ariane, we need to make sure that we're leaving room for our audience to ask questions. Do you have some questions from the chat? I have a million more that I could ask, but we want to make sure that our audience is able to ask some.
Yeah, the chat question for now are just from panelists. So if somebody is not a panelist who wants to ask a question, just put the raise hand thing. And in the meantime, Pamela, ask your next question.
Oh, thank you. So I do have one for Heather. Heather, this question is for you. Now, I wonder about the way in which women are getting are advancing, for example, their pay. And there are always these evaluations that are going on. So I'm just wondering, are there job evaluation schemes that cause pay discrimination or race discrimination with respect to pay? Tell us what your research is finding and showing there.
Yeah, sure. We have found that there isn't a single private sector off-the-shelf job evaluation scheme that isn't discriminatory. So, hey, for instance, which I think you do have in the States, it may be called something else now, builds in gender discrimination, absolutely, into the system, which is why we have developed our own schemes for the National Health Service and local government and so on, that it's not possible to have an off-the-peg scheme and use it with any security at all about delivering a non-discriminatory pay structure.
So, well, that's good to know. I just thought of one other thing that I don't know if we brought this up. When you work for the government and you think you're not being paid fairly, one of the things that you can do is ask for a desk audit. And you say, look at all the work that I'm doing, and it exceeds far beyond what I'm being paid. Like, what could individuals who are working in the private sector do? Do they have the same type of option that they can ask for these sorts of desk audits to show I'm not being paid what I should be paid? And Mr. Employer, you need to look at that a little bit closer. So panelists, what do you think about that? Trilby, let me know. Tell me, help us.
Boy, that's a tough question. I mean, I'm interested in my panelists' reaction too. There's no law that requires that because there's so much of the lack of pay transparency under the federal laws, there's no law, I think, that would require an employer to come out when asked that question and say, well, Bob, who sits next door, your pay is in X or Y place in relation to his. I was just thinking, Pamela, about the fact that I'm a government employee, and in California, our salaries are all public, right? And so that's obviously a totally different situation. In the private sector, I'm struggling to find a great tool to do that, other than, I guess there's always asking, but I'm not optimistic that many employers are just going to do that out of the goodness of their heart. What do the rest of you think?
I would like to go back to what Heather said, that the whether we can come up with more collective provisions, because having to bring a case, having to ask for an order, having to discuss pay, it's an individualized way of dealing with it, which really exposes the person to retaliation, or, it requires super strength. And so what I found most interesting, and Heather's examples to some extent, is the Australian piece where this is their sector bargaining. And so that goes beyond individual employers and sets a baseline through collective bargaining, which I think in the US, maybe we have in the Minnesota equal pay scheme, which really systematically uses a comparable worth approach for government employees. But I think there aren't that many groups. I don't know, anybody else?
Yeah, just a quick note that I agree with you, Ariane, but less than 10% of employers in the United States are unionized.
Yeah. Yes.
Well, Ariane, looks like we're at the end of our hour. I just want to say this panel is just incredibly awesome, and we didn't have enough time to talk more in depth about everything else that could be here. So I'm going to turn this back over to you so that we don't, go too far over time.
Well, thank you very much, everybody. Just wanted to say Equal Pay Today, we have a research group if people are interested in being part of that. And we also, I was going to put in the note, forgot, but we are having a webinar on on Thursday, the 9th, to look at occupational segregation where Trilby and I will speak, but also to look at the link between actual trends and what the law can and has been done, which may be of interest to some of you. Anyways, thank you very much. And thank you also everybody for staying so much on time, very clear presentations, and thanks for attending. And unfortunately, we keep going on this. It's quite a while for equal pay. So thanks.